Committee on Financial Services will come to order. Without objection, the chair is authorized to declare a recess of the committee at any time pursuant to Clause 2JL of House Rule 11. Today's hearing is a continuation of Wednesday's hearing titled American Innovation, the Future of Digital Assets from Blueprint to Functional Network. Without objection, all members will have 5 legislative days within which to submit extraneous material to the chair for inclusion in the record. I now recognize myself for 4 minutes for an opening statement. For years, this committee has worked in a bipartisan manner to move forward meaningful market structure legislation. Just last year, FIT 21 passed the House with 71 Democrats supporting the bill, the precursor of our work in this Congress. The Clarity Act builds on that work. My colleagues across the aisle have always had a seat at the table to engage in productive discussions about digital asset market structure legislation. These conversations, often tough but always thoughtful, help shape the framework that we have been crafting during this Congress. Over the past 5 months, our committee has held 4 hearings and a roundtable on digital assets to examine the need for a dollar-backed payment stablecoin and market structure framework legislation. The minority has had an opportunity to ask questions of witnesses, share concerns, and raise issues at what was supposed to be a joint hearing with the House Agriculture Committee in early May. Instead, the ranking member chose to object, walk out, and host her own roundtable discussion on the exact same topic that we're talking about here today. Despite last month's theatrics, members from both parties have had ample opportunity to share their views, voice their concerns, and engage in thoughtful discussion. Our consumers, our digital asset developers, and our financial markets all deserve clarity, and it's past time that the industry deserves it. We must move forward with our important work to provide the rules of the road for digital assets. Currently, there is no federal framework for non-security digital assets. We're here today because of the failures of the past. Any activity taking place in digital assets today is taking place under that regime, or lack thereof, as set forth by the Biden administration. We've had real opportunities to deliver this much-needed framework in the past, but under the Biden administration, and particularly former SEC Chair Gary Gensler, that progress was stalled. Frustratingly, this is despite the Biden administration's executive order urging Congress to take action on stablecoins, regulating spot Bitcoin, and crafting a legislated market structure framework. The administration ended up, though, preferred ruling by enforcement rather than providing the clarity through a regulatory framework that would protect investors, consumers, and maintain America as the leader in this innovative technology. Now is the time to step up, rise to the occasion. Under the Clarity Act, all digital asset companies will be subject to the rules and regulations within this bill, rules and regulations that do not currently exist for these assets. And all digital assets and participants engaging with digital assets are subject to vigorous AML, BSA, anti-fraud, anti-manipulation rules on the books. Digital assets have historically been a bipartisan issue in Congress, and we should continue that tradition. Together, we can bring clarity to this industry and keep America at the forefront of innovation. To my friends across the aisle, let's continue our work together. Let's engage on this important effort so that we can move forward towards meaningful legislation and deliver results deserved for our financial markets, our innovators, and our consumers. With that, I yield back, and I recognize the ranking member of the full committee, Mrs. Waters, for 4 minutes for an opening statement.
Thank you very much, Chairman Hill. I'd like to take a moment to do a little bit of an explanation about what is known as Minority Day. This is Minority Day, and I did not expect the chairman to be here, but that's his right to be here. He is the chair of this committee. He knows the rules, and I'm so pleased that he joined us on Minority Day. Minority Day is organized by the opposite party in order to get more information out, in order to straighten the record, in order to make sure that The path that we're on is well understood, why it is necessary to have more information. So, despite the fact that I did not know the chairman was going to take over today, I'm very pleased about it because he get a chance to hear even some of the information that has not been explored during the regular committee hearing. So, let me start by saying, the unfortunate reality is that Republicans on this committee refuse to openly admit that Donald Trump is abusing his position as president to enrich himself off crypto. This is an unusual time in the history of this country. And while we disagree on many issues, sometimes we're able to compromise, we're able to work together. There are other times it is more difficult, but this is highly unusual that we have the President of the United States that's enriching himself off of this cryptocurrency, a president of the United States who's enriching his family, a president of the United States in the middle of our negotiations is creating more opportunities for himself, whether it is on crypto as you know it, a stable coin, et cetera, et cetera. And so, the Republicans have ignored the $sign Trump meme coin that has collectively lost his investors $2 billion while he pocketed $350 million. They've ignored the meme coin dinner where guests, this is outrageous, spent $140 million to curry favor from the White House, but were instead served cheap food and ditched by Trump after 20 minutes. It wasn't about a dinner. It was about connecting with the president and gaining favor. And so you show up, you spend all of this money, you get to know him, and you want to ride the train of increasing your wealth on crypto. And so they have ignored the ways Melania and her sons, Eric and Donald Trump Jr., have used crypto to multiply their family's wealth. They've ignored World Liberty Financial and the various crypto deals Trump has brokered in the Middle East that have exploded his wealth, even as Americans are getting poor and being squeezed by Trump's tariffs. They've ignored what is undoubtedly the biggest scam and abuse of power in the history so they can jam through a dangerous crypto market structure that I call the complexity structure. Not a single provision in this bill addresses the crimes I've laid out. In fact, this bill only legitimizes it. So, committee Democrats have been left with no choice but to force Republicans to convene a hearing with our own witnesses where we will discuss what Republicans are so afraid to do, openly and honestly address Trump's crypto crimes. Let me be clear. Next Tuesday, committee Republicans are rushing to pass what I call the Complexity Act without addressing these concerns that not just Democrats, but also the American public, the crypto industry, and even some in their own administration have raised regarding this bill. And while the lack of provisions to stop Trump's crypto
I now recognize the ranking member of the chair of the Digital Assets Financial Technology. You're over time, Madam Ranking Member.
Mr. Chairman,
Gentlewoman.
Point of privilege. How long did you take with your opening statement?
4 minutes.
It looked longer.
Well, that's because it was the truth.
Oh, my goodness. Well, we're going to see who's telling the truth today.
I now recognize the chair of the Digital Assets, Financial Technology, and Artificial Intelligence Subcommittee, Mr. Stile, for 1 minute for an opening statement.
Thank you very much, Mr. Chairman. Another great opportunity to discuss the bill. And I hope that's what we actually do today. We've had many opportunities to do just that. We're building on a lot of great work that was done in a bipartisan way last Congress. We saw when Fit 21 came to the floor, over 70 Democrats come to the table to try to solve a complex problem. A problem that really Gary Gensler and the Biden administration in many ways put us in, delivering us meme coins, lack of clarity, pushing businesses offshore, And I hope this doesn't devolve into discussions of Trump derangement syndrome. I hope we use this opportunity to truly focus on the legislative text before us, because the legislative text before us is very good, solving a real-world problem. We've had many opportunities. I know the ranking member of the full committee objected to a joint hearing that we held between us and Ag and walked out. I think that was a missed opportunity to dive into the details of the bill, and I think if we focus on the bill, we can be productive. I yield back.
Gentleman yields back. The chair recognizes the ranking member of the Digital Assets, Financial Technology, and Artificial Intelligence, Mr. Lynch of Massachusetts, for 1 minute for an opening statement.
Thank you, Mr. Chairman, and thank you, Ranking Member Waters, for requesting this minority day hearing. My Republican colleagues are rushing to pass a crypto market structure bill that not only fails to crack down on Trump's crypto corruption, but also endangers our traditional banking system, weakens investor protections, national security, and lets crypto criminals off the hook. I predict that the next financial crisis will certainly be driven by reckless crypto activities that this Congress would have allowed this bill if this bill passes. We must act to ensure our robust financial and security laws are not threatened. Republicans repeatedly rejected my amendments to protect American taxpayers by prohibiting a taxpayer bailout. My Republican colleagues refuse to even acknowledge President Trump's crypto corruption, which undermines their efforts to pass this bill. I assume out of fear and backlash from the President. My Democratic colleagues and I have no fear of this President, which is why we will continue to fight this legislation and any actions that threaten our democracy. Thank you, Mr. Chairman, and I yield back.
Gentleman yields back. Today we welcome the testimony of Ms. Carol House, who's a senior fellow at the Atlantic Council Geoeconomic Center, Professor Hillary Allen, who's a professor of law at the American University Washington College of Law, Mr. Bartlett Collins-Naylor, a financial policy advocate and economist at Public Citizen, Ms. Amanda Fisher, who's the policy director and chief operations officer at Better Markets, and the Honorable Timothy Massett, research fellow and director of the Digital Assets Policy Project at Harvard Kennedy School of Government and former chair of the CFTC. We thank each of you for taking time to be with us today. You'll be recognized for 5 minutes to give an oral presentation of your testimony without objection. Your written statement will be made part of the record, and we'll start with you, Ms. House. You're now recognized for 5 minutes.
Thank you, Chairman Hill, Ranking Member Waters, and distinguished members of the committee for holding this hearing continuation and the honor of the invitation to testify. I applaud your leadership in continuing the years-long effort of building legislation around cryptocurrency regulation. I've spent much of my career leading cryptocurrency efforts at the National Security Council, at FinCEN, and in industry advising 3 different regulatory bodies. In this time, I have observed massive changes in the digital asset ecosystem, including enormous growth and collapses, experimentation in underlying technologies, business models, and use cases, seen rampant fraud and exploitation of consumers, as well as use for money laundering, meeting with victims that had thought about killing themselves after losing their life savings and being defrauded in pig butchering scams, and finally witnessing innovations by licit actors to explore avenues like programmable compliance and RegTech solutions, but also innovations by illicit actors who are continuously optimizing and obscuring their laundering and scamming techniques. The current alignment and implementation of protections in digital assets is not working. Just as one example, the largest heist in history just occurred earlier this year targeting this sector, perpetrated by North Korean actors stealing $1.5 billion in one hack as part of revenue generation for a regime guilty of human rights violations and proliferation activities. Though you wouldn't know that attending most cryptocurrency conferences. Unfortunately, this incident also was not in a vacuum, but instead is part of another cyber theft after part of a years-long building trend in this industry exploiting both pervasive cybersecurity and money laundering vulnerabilities. This also underscores how we need to strengthen implementation of a prudential regulatory framework for crypto. I applaud Congress for pursuing digital asset legislation to ensure appropriate regulation in the United States. Regulation ensures that we demand legitimate and responsible activity within the industry and to provide legitimate authorities and levers to supervisors and enforcement agencies to hold accountable illicit actors. The stated goals of the Clarity Act to help address regulatory gaps and provide clarity are laudable. Unfortunately, I do not believe that the current text achieves these goals. Key tenets of the proposed legislation as drafted appear to be overly complex as they try to rewrite existing markets regulations into a bespoke regime, forging notable gaps for coverage under consumer and market protections rather than closing them. It leaves insufficiently or unaddressed key areas like meaningful implementation and enforcement measures for countering illicit finance and cybersecurity, and it departs from long bipartisan stated principles of tech neutrality that would enable regulations to persist in the face of continuous technological innovation. I'm concerned about departing from long-standing precedent of protections that we expect in markets that appear present here with less rigorous disclosure and capital requirements, unclear authorities for non-security spots markets, weaker restrictions on functions and conflicts of interest across custody, market making, and trading, and confusing definitions that appear optimized to expand gaps of coverage for arbitrage opportunities around concepts like decentralization. At least in my view, the mark of maturization should not be centered around there being an absence of entities taking responsibility and accountability for governance. I also want to underscore that there seems to be a major gap on areas affecting national security in this bill. As some have said in Wednesday's hearing, that legislation should be based on facts. This bill needs to clearly address the factual reality of exploitation of crypto by nation states, corrupt regimes, and transnational organized crime due to weak protections. This bill should explicitly outline not just application of the BSA, but high AML standards that we have for other covered institutions like customer identification programs, as well as cybersecurity requirements around access management, key protections, and third-party risk management that have been culprits in a lot of the major incidents. No one likes getting robbed. It should address the current dismantling of the enforcement apparatus as well that's happening across agencies, and instead ensuring appropriate resourcing, expanded authorities, capabilities, and prioritization for timely enforcement against the worst actors in this industry. I'll close with recommending that policymakers consider an alternative approach, setting out a legislative framework for joint regulatory action by the SEC and CFTC, which has precedent in Dodd-Frank. I encourage Congress to consider a more streamlined approach that sets out clear authorities and a mandate for joint SEC and CFTC action, creating clear pathways for registration, outlines clear principles for protecting markets and consumers, and establishes explicit mandates and appropriations for AML and cybersecurity protections and enforcement. Finally, it should initiate work by the SEC and CFTC together to take the steps that were already advised by the CFTC's Technology Advisory Committee in the DeFi report to evaluate and address DeFi's unique features and challenges. Thank you. I look forward to your questions.
The gentlewoman yields back. Professor Allen's recognized for 5 minutes.
Thank you. Chairman Hill, Ranking Member Waters, and members of the committee, thank you for inviting me to testify at today's hearing. My name is Hillary Allen, and I'm a professor of law at the American University Washington College of Law. We are here to talk about a bill designed to supplant long-standing securities laws that were enacted to protect the public from harm. In many ways, the timing of this bill could not be worse. Many Americans already faced economic precarity, with roughly half of the country living paycheck to paycheck. We are now at a moment, though, when prices are increasing, and there are legislative attempts afoot to further shrink the social safety nets that many people rely upon. In times of increasing economic desperation, people become more vulnerable to predation and gambling increases. Crypto investing is not investing in the traditional sense, where investments in productive enterprises yield the possibility of a win-win outcome for both the investor and the enterprise. For most crypto assets, the only reason why they have any value is because of the possibility that someone else might be willing to pay a higher price for them. Unless an everlasting supply of new money can be drawn into buying the crypto asset, then its price will start to go down whenever the larger holders cash out, potentially toppling the whole edifice. Crypto investing is speculative gambling, and in these kinds of situations, increasing access by eliminating regulation of crypto issuers is tantamount to throwing little fish to the sharks. This bill proceeds on the basis of many fictions, including that crypto assets have no issuers. Another such fiction is that digital commodities have a value that is substantially derived from the blockchain system. I would ask whether the value of a bank account is derived from the type of software a bank uses to maintain its deposit records. The answer is obviously no. No value is conferred by the type of technological plumbing used to record ownership. The most glaring fiction in this bill, though, is the idea that the use of blockchain technology guarantees decentralized...
The witness will suspend. We just want to make sure we get the tech right. It sounds like the microphone may not be on the live feed, so let's just suspend for a moment.
There we go. Glad to know it wasn't me. Let's see. The most glaring fiction in this bill is the idea that the use of blockchain technology guarantees decentralization of economic power. It does not, and the crypto markets are rife with concentrated economic power, even in the parts that purport to be DeFi. This fiction is a linchpin of the bill, notwithstanding that the bill concedes that centralized control of blockchains will be necessary and can be exercised in emergencies. It should be obvious that if control can be exercised to protect blockchain users, it can also be weaponized against them. What is even more concerning is that mere aspirations to decentralization are considered sufficient to invoke some of the dispensations in this regulatory regime. We don't let tweens drive cars today because they aspire to one day be immature enough to do so. We shouldn't let issuers of what would otherwise be securities escape the securities laws because they aspire to one day reach decentralization nirvana. If this bill becomes law, it will upset bedrock legal structures that undergird our financial markets, particularly because it's hard to predict how its complexities will play out. It is somewhat surprising that Congress is moving so swiftly on legislation that risks undermining the stability of our financial markets, particularly when so few Americans currently show any interest in crypto or its underlying blockchain technology. The Federal Reserve recently reported in its SHED report that only 2% of surveyed adults said they use cryptocurrency to make a financial transaction even once in a 12-month period. The St. Louis Fed recently reported that only about 4.3% of U.S. households owned any cryptocurrency at all in 2022, and lots of them owned small amounts only. Tellingly, although the crypto industry was responsible for 44% of all corporate expenditures on the 2024 election cycle, the political advertisements funded by that money did not mention crypto. The notion of the crypto voter is by and large a myth. I want to close by saying a few words about the relationship between innovation and the law. Regulation is not an obstacle to innovation. It channels innovation to reflect priorities determined through the democratic process. Exemptions from regulation work as a subsidy that can prop up technologies and business models that might have little to recommend them on a level legal playing field. If this bill were to become law, that would be tantamount to the government picking winners among businesses, allocating a subsidy to those who use blockchain technology at the expense of other technological rails. Right now, medical, scientific, and other important technological innovations are not being funded. So that begs the question of why blockchain innovation is being prioritized by our elected representatives at this moment. The primary use cases for crypto are speculation and funding illicit activity. If the crypto industry has socially useful capital formation benefits to offer beyond that, it should be able to demonstrate that within the existing securities laws framework. Thank you very much.
The witness yields back. Mr. Naylor is recognized for 5 minutes.
Style, Ranking Member Waters, members. It is my honor to sit in the reflected esteem of my fellow panelists, my fellow Idahoan. Perhaps the most clear-headed, articulate finance law professors in the nation, the Chief of Staff of the Securities and Exchange Commission, the Chair of the Commodity Futures Trading Commission. But it is also a solemn time because I believe that when the Ron Chernow or the Steven Spielberg or the Lin-Manuel Miranda of 200 years from now writes or does a musical about this president, they may well take a deep dive into this hearing because what's going on is the greatest corruption in presidential history. George Washington alerted his stepson to buy the very land that we're on before he designated it as the nation's capital. President Lincoln apparently sold sinecures to secure the 13th Amendment. My source for that is Steven Spielberg. And President Obama wore a brown suit. Now, these are definitely things to be concerned about, but the Trump corruption is just beyond any of that. Now, I was the head of investigation for the Senate Banking Committee, but it does not take anything but somebody watching social media to see these corruptions. I personally believe I witnessed a federal crime on May 22nd when I stood outside the Trump golf course and watched the co-conspirators in. Now, they weren't wearing ski masks, but they were identifiable because they had tuxedos on. And these are people that paid a collective $148 million for the favor of being with the president, as the ranking member has so articulately put it. Now, what are these schemes? Again, just look at social media. There's at least 3 violations at stake here. One is that the president may receive gifts, news to me, that he may receive gifts, but he cannot solicit gifts. And that's what I believe he is doing when he sells the Trump meme. And again, he's not offering you anything. He says this is not an investment. His Securities and Exchange Commission put out guidance saying this is without value. So basically he's saying, give me money. I want money. Second, the president can't get an emolument. He can't get a gift from a foreign king or prince or a government. And he's doing that. It's many examples, but the $2 billion stable coin is just one of them. And you can't sell favors. You can't say, give me money and I'll host you at a dinner. Or you might be under investigation by the SEC, but if you give me $30, $50 million, I'll terminate that. So you can't do any of that. Now, I appreciate that Pam Bondi and the Office of Government Ethics are not returning our letters where we've asked for an investigation, but there is something that you can physically do beyond this hearing, and that is you can ask the GAO to determine that his Trump meme promotion is a solicitation of a gift, and that in turn helps the next responsible administration with an independent Department of Justice and Attorney General to lay the groundwork for a successful prosecution. He is not immune from this. This is not an official act. He has helpfully told us that. His press secretary has said his meme gala was on his personal time. So again, I would urge that this committee ask for the GAO report, and finally, and most importantly, no responsible member of Congress can vote on a bill that legitimizes or advances stablecoins or other cryptocurrencies while we are witnessing the greatest corruption in presidential history. Thank you.
The witness yields back. Ms. Fisher is recognized for 5 minutes.
Good morning, Chairman Stile, Ranking Member Waters, and members of the committee. Thank you for inviting me to testify today. My name is Amanda Fisher, and I'm the Policy Director and COO at Better Markets, a nonprofit, nonpartisan, and independent organization founded in the wake of the devastating 2008 financial crisis. Today, I want to provide a few thoughts on the context in which this bill is being considered, and then I want to provide some thoughts on specific aspects of the Complexity Act that I think are dangerous. And all of my comments today are an abbreviation of a long document that I submitted that thoroughly goes through the bill. So first, the context in which Congress is considering this bill. I agree with the ranking member that the chairman is not allowed adequate time to consider this wide-reaching proposal. I myself have read it multiple times and consulted with top securities law experts, and I'm still unclear about the application of many provisions in the bill. Ranking member Waters is correct to demand technical assistance from the subject matter experts at the SEC without any withholding or editing by the chair's crypto task force. That is a standard that we upheld in the last administration, and the professional experts at the SEC deserve to have their voices heard by all members and their staff. Second, the financial regulatory agencies are under siege. Democratic commissioners nominated by the president and confirmed by the Senate have been fired without cause. Soon the CFTC will have only one commissioner. By the end of the year, the SEC will be down to a 3-member commission of all Republicans, notwithstanding that they have a statutory mandate of bipartisanship. The CFPB is on life support. The president has threatened to fire the Fed chair, and the previous vice chair self-demoted in avoidance of being fired. Third, the president signed a dangerous executive order in February placing the formerly independent regulatory agencies under White House control. Again, this is dangerous. And fourth, the administrative law context in the courts has become openly hostile to regulators using the authorities granted from Congress to engage in rulemaking. This bill includes many, many instances where Congress punts on providing specific directives. Given the spate of recent Supreme Court rulings, that is very concerning. As for the bill itself, the bill will blow a hole through the laws wisely put in place by the Congress after the Great Depression and replace it with a shoddy regime that is deliberately fuzzy and loophole-ridden. The bill provides concepts of a plan on key investor protections, and it sends most crypto regulation to the CFTC even though that agency was created for non-retail commercial buyers and sellers of futures and swaps. To go through a few provisions of the bill, first, the offering regime. There are so many investor protection exemptions for crypto to sell their investments to the public under this bill that I don't even think anyone will resort to using the dangerously broad process at the SEC. Crypto issuers will claim their DeFi, claim that they're not offering investment contracts. They'll claim that they're collectibles or meme coins. They'll claim that they're airdrops, or they'll claim that they're subject to the grandfathering provision. For those that do use the exempt offering framework at the SEC, that too is vastly permissive. The trading regime in this bill is likewise light touch. It defers to the crypto exchanges themselves on how to comply with a vague set of core principles. This is in contrast to the national securities exchanges, which are subject to tight rules requiring affirmative SEC approval. Instead of the competitive tensions we see right now between exchanges and broker-dealers, crypto exchanges will unilaterally set the rules on fees, trading protocols, and key features. Exchanges may well be able to keep their venture capital affiliates. There are wide exemptions for trading on their own exchanges, and there are weak cybersecurity safeguards. With regard to the brokering and custody regime, no fiduciary duty, no regulation best interest, no best execution rules. There are very few protections for data breach notifications or for arbitration. And likewise, there are many gaps in the custody framework, with investors having unclear rights to their own assets, and we could bring back the crypto lending models of now bankrupt BlockFi, Voyager, and Celsius. I will just conclude by saying, perhaps most profoundly, this bill's regulatory gaps will not be quarantined to crypto. Over time, we will see more and more companies shoehorn their capital raising efforts onto the blockchain because of regulatory arbitrage instead of legitimate business need. The CEO of Robinhood said on CNBC that it's 10 times cheaper for him to run his crypto business than his equities and options business. Why? He doesn't have to pay for customer protection, SEC exams, or SIPC insurance. Of course it's cheaper. I do not think that that's the type of innovation that's good for consumers.
The witness yields back. Mr. Massett is recognized for 5 minutes.
Chair Stile, Ranking Member Waters, members of the committee and staff, thank you for inviting me to testify. The views I express are my own and do not represent the views of the Kennedy School of Government. I appeared before you yesterday. My views have not changed in 48 hours. Thank you for inviting me back. I still believe the Clarity Act will not provide the investor protection that we need, nor will it provide the clarity. And it's vital to understand why that is in some detail, because this isn't and shouldn't be about whether you are for or against the technology. I strongly believe the technology is potentially very useful. I just think there's a better way to do this. Let me quickly summarize what I said yesterday. I don't want to repeat myself verbatim, and then maybe suggest a couple of ways to think about this. First of all, I agree with Ranking Member Waters' concerns about the President's activities. I also agree with some of the concerns that Chair Hill expressed in terms of what we need to be doing here. I suggested Wednesday that the primary goal should be to provide a regulatory framework for the spot market in digital assets that are not securities. That gap has been the reason for fraud, manipulation, rampant speculation. That gap has largely resulted from our fragmented regulatory system. So I think the solution does need to bring the agencies together, not just in a few rulemakings, but in a structural way. I outlined an approach that former SEC Chair Jay Clayton, a Trump appointee, and I had suggested some 2 years ago, and a key aspect of that was it's a way to establish jurisdiction through joint rules without rewriting or overturning existing securities and derivatives laws. The Clarity Act obviously addresses the gap in regulation, but it does so in a way that I suggested violated two key principles, the do no harm principle and the keep it simple principle. Do no harm meaning that we should not undermine the legal framework of our existing securities and derivatives markets, and the keep it simple principle is self-evident. But the point is that we shouldn't create legislation that is so complicated that it creates endless opportunities for regulatory arbitrage by clever lawyers, arbitrage that will in many cases lead to undermining that traditional framework. And it shouldn't be so detailed that it puts regulators in a straitjacket. we don't want to deprive regulators of the authority and flexibility to respond to the endless ways in which clever lawyers might subvert legislation, as well as the authority and flexibility to respond to changes in market conditions and the evolution of technology. I hope we can get into a discussion of some of the specifics. I appreciate in particular Ms. Fisher's comments on some of the particular issues that concern her, and I share those concerns. I won't repeat those. Let me go, though, use the last minute or so just to give you an analogy of maybe a way to think about what we're trying to do. Analogies are never perfect. They should not be taken too far. But imagine that driverless cars are more common than they are today, but that they still represent a small part of the market. And imagine that Hertz and Avis even rent them. And I rent one, and I'm in the back seat, and the car goes through a red light, and there's a crash, and somebody dies. We should not say, oh, well, don't produce driverless cars, because it is technology. We need to perfect it. We need to move forward. But we also shouldn't say, well, the guy who died, you know, it's his fault. He should have known there are driverless cars on the road, and even if we required them to be painted red with green spots, he still shouldn't just suffer the liability. So then the question is, how do we allocate liability? Is the manufacturer liable? Maybe it produced the car incorrectly. Maybe the code was wrong, and maybe there's someone up the chain who should be held responsible. Is Hertz liable because they didn't install an upgrade? Am I liable because maybe there were routing options and I overrode the routing option that said observe stop signs or red lights? So we need laws, we need rules, but those shouldn't undermine the rules that pertain to the rest of the cars. And this is a new area. It is evolving. We cannot write today something that is anywhere near as detailed as the Clarity Act, and all of us can point out why. We need more of a principles-based approach that allows us to move forward. Thank you.
The gentleman yields back. We'll now begin with, we'll turn to member questions. I'll now recognize the gentleman from Ohio, Mr. Davidson, Chair of the Subcommittee of National Security, recognized for 5 minutes for questions.
Thank you, Chairman Stile. Yeah, there we go. Little technology issue here. Look, thank you for responding to this opportunity to talk more about the Clarity Act. I really think it was sort of unscheduled at the beginning of the week, but it's a great time to talk about a great bill. We've worked for years. I mean, I remember back in 2017 when the initial coin offering market was exploding, and I was a new member of this Financial Services Committee being alarmed, like, shouldn't we be doing something about this? And we didn't. And then 2018 was going by, and we didn't. And so I convened a hearing at the Library of Congress to talk about what needed to be done. And frankly, it still needs to be done. You need a bright line test to define what is and what is not a security. People have tried to apply the Howey test, but it's a court decision. It's not even in statute. And then under the guise of, much as Professor Mossad just highlighted, of supporting the bill, people have spent essentially half a generation working to undermine the industry. They say, oh, no, I support the industry. Gary Gensler was one of those guys. He taught at MIT, and then he became the chairman of the SEC, and I was hopeful that finally we would have somebody that really understands the technology who we could make progress on. But what he really did was serve the interests of Elizabeth Warren and become the leader, the face of the anti-crypto army. So while the industry broadly sees themselves as left of center politically, politics, make no mistake, has stopped the legal clarity that this market needs. It's 100% Democrat opposition to progress in this bill, and that's continuing to this day. And I think that's disappointing. I think a lot of people in the industry would like to see us work together to get this done. And frankly, I welcome, I kind of like the policy part of this and hate the politics part of it. But the politics part's been fine for Republicans. Right? You've got single issue voters that have come over and said, let us be in support of the Trump administration. I mean, they were a huge win for us flipping Silicon Valley. I mean, David Sachs being part of Treasury, all this kind of momentum is great for the GOP and our party. But the right policy eventually makes good politics. And I think that's the thing we need to focus on here. What is the policy? This does provide the bright line test. And while people say, oh, well, I'm just concerned about investor protection, let's be clear what kind of investor protection you've provided. You kept people from being able to put Bitcoin in their 401ks for 10 years. In 2013, the first applications for Bitcoin ETFs were made, and the market wanted to do this. The market was ready to do that. The demand was there for it, but the regulators wouldn't provide the clarity that was there. And as it turned out, the SEC seemed to have the authority to do it all along, because they did. It wasn't because we took action and passed a law. So thankfully, the industry hasn't waited for us. In that time, Bitcoin appreciated from $500 or $600, well, in 2013, $200 to now $105,000. But I guess everybody's wrong, right? So you have these people that are just convinced that this isn't really going to be a thing. What you've protected people from is making money. And the last thing, one of the best ways to protect people, we finally got in this bill in a very important way, which is self-custody. So we like to trust our institutions. We have regulatory bodies that are supposed to make sure that the institution and, frankly, the industry is providing good consumer protections, and I think this bill does a pretty good job of doing that. But at the end of the day, self-custody is I trust myself with my assets. It is personal property at the end of the day. And so the protection for self-custody is vital. I think the future, you're going to see things that take from where this bill leaves off, where we create something called a digital commodity. So of course, there has to be a way to do capital formation for something that isn't a security or isn't a commodity. It's a digital commodity. So it's got its own path for capital formation. Securities are securities, but there are going to be people that want to tokenize them, and they are. There will be tokenized exchanges, and people will want to list on those. And this bill says to the SEC, do a study on that. I hope we follow up and provide legal clarity on exactly how to tokenize securities. The same is going to happen with tokenized commodities, and we're seeing a massive market for tokenized real-world assets. And so I think this is the start of a progress that we need to get through the finish line, and we need to stop pretending that we're for an industry while working to undermine it by preventing legal clarity. We need to pass this bill. I yield back.
The gentleman yields back. We will do one more member question prior to breaking for votes. I now recognize the ranking member of the full committee, Ms. Waters.
Thank you very much. I do believe that our panelists here have identified the complexity and the problems with this bill. Market structure is a bad bill. It is a bad bill in every way that you can possibly describe what is wrong with this bill. And so, some members have talked about amendments to the bill. Some members have talked about jurisdiction. You heard a little bit about still the confusion around whether or not it's a security or commodity, on and on and on. Now, Mr. Taylor, you made a very, very strong, profound statement. You said that what this president is doing is more corrupt than has been done by any president in the history of this country. So after those who are interested in trying to make it a better bill and coming up with all these amendments, the President of the United States is now in control of all our independent agencies. He said to the SEC, you don't do anything before you bring it to me. I'm in charge here. So what good does it do to talk about amendments when you have a corrupt president who's enriching himself and his family, who's brazen in the way that he's doing it? Please comment for me.
Yes, Ranking Member Waters, if you wrote this bill with the help of Elizabeth Waters and Brad Sherman and all the smart, progressive, consumer-minded people, but you didn't have a ban that forced the sale of Trump's crypto, that would be inferior. Even your bill we would oppose if you did not ban Trump's crypto grid.
Well, and I feel strongly about that. The president has demonstrated that he has no concern or respect for the people of this country in the way that he has brazenly taken on enriching himself with the ownership of crypto. Mr. Davison just said that what we're doing is stopping people from making money. No, I want to stop the President of the United States and his family, Melania, and his sons from all owning crypto, and the members of Congress and the cabinet. None of us should be in a position where we own crypto and enrich ourselves at the expense of the people. And so my bill is all about stopping Trump in the Crypto Act. My bill is very clear, and I want to just say this to mention that I am not adamantly forever opposed to crypto. Perhaps we can work out some of the jurisdictional issues, et cetera, sometime in the future. But what I'm opposed to in this act, my bill that I have, again, and I will reiterate, the crooked President of the United States of America, who's decided to use the office of the presidency to enhance his access to profits. I mean, that's what it's all about. And so, thank you. If we do all these amendments that people are talking about, I'm going to vote for crypto because we're going to amend it. It does no good. What you're doing is strengthening the president. Democrats can't do this because we're trying very hard to change the direction of this country. We're trying to encourage voters that something's wrong with the direction of the President of the United States, but we empower him if, in fact, we leave him as being able to own and control crypto and enrich himself. So I want to be very, very clear about that. This bill, with all the amendments that can be made, if we allow the President and the Cabinet and the family and the members of Congress to own and control crypto, we've done nothing but enhance his ability to stay in office with additional money, more money coming to him from all over the world, as been done with Abu Dhabi. How much did Abu Dhabi put into this Trump?
I'm aware of $2 billion.
$2 billion through Binance. That's where I think it went. Look, we are very clear about all of this, and we just want to make sure that the members have the correct information and all of the information by which to make a decision.
The gentlewoman's time has expired. Pursuant to the previous order, the chair declares the committee in recess, subject to the call of the chair. Will reconvene immediately following votes. The committee stands in recess.
Testing 1 2. Testing 1 2. Testing 1.
I assume we told all our witnesses that too.
Audio check 1 2. Test 1 2 3 4. Audio check 1 2. Is he getting my audio check? Audio check 1 2. Test 1 2 3 4. Audio check 1 2 3 4.
on the bill, but a lot of comments on President Trump, which is a little bit of the continuation of Trump derangement syndrome that we sometimes see on this committee. I think it could be a real opportunity to dive into the substance of the bill, which is, I remind everyone, a bipartisan piece of legislation. It's not common that I would quote Minority Leader Jeffries, but it might be appropriate just to remind everyone what he said just as of Tuesday of this week in a hearing when asked about crypto legislation. He said, quote, "There are allies of the crypto industries on both sides of the aisle in the House," end quote. He then went on to say, "I think substantively, figuring out how we arrive at a bipartisan resolution of the crypto issues that are currently pending before Congress is what will best serve the American people and also best serve in appropriately regulating the industry that allows for innovation, but also has guardrails to protect the American consumer," end quote. And so you see, Leader Jeffries, you see this piece of legislation actually calling for all of us to come together to recognize that the current state of affairs is incredibly unproductive. And here's the fallacy that I often see of the argument of the left of some of those on this committee, not those that have engaged substantively. And again, I recognize this legislation has strong bipartisan support. The fallacy of the left of some of those who don't want to engage is what I call the nanny state fallacy, which is if you have to go to the government to get permission to act, it's an idea that failure to get that permission will then end the behavior. And the fallacy there is that really that behavior just simply moves offshore outside the realm of regulation. That's exactly really what we saw during the Biden administration with Gary Gensler in charge of the SEC. What we actually saw was a lot of the innovation and development occurring outside the United States, outside our norms and standards, without appropriate regulation. So if you're concerned for consumer protection as I am, and you don't want to see another FTX where individuals lost their money, Mr. Chairman, the committee is not in order. I'll continue.
Gentleman can proceed.
What we really saw during the Biden administration with Gary Gensler in charge was this innovation development occurring offshore, really to the detriment of many people who were putting investment money, time, or effort into this space. And so if you look back at FTX, the lesson that I think in many ways that should be learned was instead of allowing that to occur offshore in an unregulated manner, in addition to having unethical individuals in charge, we should be working to bring this innovation development into the United States in a regulated space with clear rules of the road, which is exactly what your bill does, Mr. Chairman, puts forth clear rules of the road so that individuals can invest, innovate, and develop in this space. And so I think this is a real opportunity to make sure that we're getting this right. There's many Democrats who've come to the table in this regard, co-sponsored the legislation that you brought us forward, put forward thoughtful ideas, suggestions, but instead some of our colleagues, not all, some of our colleagues have taken an approach of putting their head in the sand. We saw earlier this year we had a joint committee scheduled between the Financial Services Subcommittee that I chair, along with the Digital Assets Subcommittee, the Agriculture Committee, chaired by my friend Dusty Johnson. At the beginning of that, the ranking member of the full committee, rather than engaging in a thoughtful, productive conversations on the merit of the bill, made a decision to object. I thought that was disappointing. It is her right, but I found that disappointing because what we're trying to do is have this conversation, discussion to get this legislation correct. And I think the introduction of the final text that you brought forward at the end of last week is a spectacular step forward to make sure that this innovation and development occurs here in the United States. And so it's not often that I've aligned myself with Minority Leader Jeffries, but I think he was right in saying that we need to come together, as we have, between committees, between parties, because this isn't about Republicans or Democrats. This is about the United States of America leading in the Web3 space. This legislation dramatically moves us forward. It's disappointing that some of the comments are not focused on the substance of the bill, or rather focused on extraneous topics. But, Mr. Chairman, I thank you for your leadership moving us forward in this nonpartisan manner that you have with the legislation. I yield back.
The gentleman yields back. The chair recognizes the gentleman from California, Mr. Sherman, who is the ranking member of our Capital Markets Subcommittee, for 5 minutes.
Mr. Chairman, I do not opposed to crypto due to Trump derangement syndrome. I was against crypto before Trump came down the escalator. And Trump was against crypto for years and years until he discovered he could make money on it. And Mr. Flood accuses some of us of falsely pretending to be trying to help the crypto industry. No one should accuse me of that. I want to thank the chair for being here. It is true that crypto is innovative. Tremendous innovative process is being made in foreign countries on recreational drugs, on AI deepfakes. Not everything that's innovative is wonderful. I agree with the proponents of this bill and the crypto industry that says 55% of Americans want clear rules of the road. And divining the rules to regulate crypto by looking at a Supreme Court case involving orange groves applying a 1930s law to a 1940s, that is an absurd way to figure out what are the rules. But this industry doesn't want clarity, it wants a patina of regulation. So what would be good, clear rules? Let me lay out what it would take for me to vote for this bill. First, no bailouts. I'm sure my Republican colleagues will agree that there should be no bailouts, but they'll never agree to any text that prohibits bailouts, because all the money and power on this issue is on the side of crypto, and they want to be able to tell people that bailouts are available. So many people will speak about bailouts, but there'll always be a reason not to put it in the bill. Second, no purchases with U.S. taxpayer dollars. The goal of crypto is to become the reserve currency for the reserve currency. Obviously, Americans do not want us to use their dollars to buy Bitcoin, let alone Skippity Toilet Coin, and imagine how rich Donald, he could be richer than Musk if the U.S. government could buy Trump coin. Fourth, no government corruption. We saw with Hunter Biden a situation where you create something at virtually no cost and effort and then allege it to have an enormous value. And he made $100,000 here and there. But we've seen with Trump coin, you create something at virtually no cost, allege it to have an enormous value, and for $300 million you sell it to the Chinese interests who own TikTok, and then you wonder why the president refuses to enforce the law he has to enforce against TikTok because they won't sell to American interests. No insider trading. Musk says he did it all for free. Somebody made $37 billion in 1 week because they knew that this new agency would be called Doge. What an absurd name, and a dog for what? $37 billion to the people who knew in advance. Fourth, no campaign contributions. Mr. Stile tells me that it would be bad for his political career if a $1,000 contribution was made in his name to the Bernie Sanders campaign. Now, I can't get a credit card in his name. I can't get a checking account in his name. But I could go and use crypto to make a $1,000 contribution to Bernie Sanders and just fill out, this is Mr. Stile. Now, the reason I don't do that isn't because I'm too cheap, although I am. It's not because I'm too honest. It is because Bernie's too honest to accept unhosted wallet, anonymous crypto campaign contributions.
Will the gentleman yield?
No, because I've got limited time. But I'll have to find another way to cause the gentleman from Wisconsin a problem. Fourth, we need the Know Your Customer anti-money laundering throughout the system. The industry will never accept that. They named their product Hidden Money, cryptocurrency. If you take the hidden money out of hidden money, it's like taking the THC out of weed, and nobody's going to buy it. Self-custody makes crypto the perfect device for drug dealers, for bankruptcy fraud, for human traffickers, but most importantly, for tax evaders. That's the big money. So we have great witnesses here, but one witness is missing. Donald Trump 1.0. So let me speak in his voice when he said in 2019, I am not a fan of Bitcoin and other cryptocurrencies which are not money and whose value is highly volatile and based on thin air. Unregulated crypto assets can facilitate unlawful behavior. including the drug trade.
Gentleman's time has expired.
Mr. Trump, you're absolutely right. Thank you.
Gentleman's time has expired. The gentleman from Nebraska, the chairman of our Housing Subcommittee, Housing and Insurance Subcommittee, Mr. Flood, you're recognized for 5 minutes.
Thank you, Mr. Chairman. It's funny, I feel like I'm having deja vu. The arguments we're hearing today from my colleagues across the aisle sound exactly like the same ones they raised when we had the first portion of this hearing on Wednesday. It makes me wonder, is this really a substantive conversation about the legislation at hand, or has this just evolved into another partisan exercise? I mentioned this on Wednesday, but I think it bears repeating in this context. While I know that some of our friends on the other side of the aisle like to talk about President Trump, it's important to remember that any current activity in digital assets is taking place under the regime set forth by the previous administration and the previous SEC. If you don't like what's happening with meme coins, you should probably agree that we need legislation. If you are concerned with what happened with the collapse of FTX in 22, which I will add took place squarely during the time of the Biden administration and Chairman Gensler, then you should probably agree that we need legislation. This committee is acting to fill a void that was left by the inaction and the foolishness of the previous administration, particularly the previous SEC. What we saw over the last 4 years was a series of repeated and embarrassing failures by the Commission. Rather than regulate, the SEC chose to litigate, and they kept losing over and over and over again. I mentioned the debt box case on Wednesday, a particularly embarrassing example where a judge actually said the SEC committed, quote, gross abuse of power, end quote, but that's not the only instance of the Commission failing on its face during Gensler's time as chair. The D.C. Circuit unanimously ruled against the SEC in the Grayscale case, with the court vacating the SEC's denial of a Bitcoin ETF as capricious and unsupported by the facts. The judge in the Ripple case rejected the SEC's sweeping attempt to label all secondary market token sales as security transactions, a ruling that gutted the Commission's entire legal theory and enforcement approach. Repeatedly, over the last 4 years, it is clear that the SEC was not living in reality, that Chairman Gensler was steering us down on a path that would lead us to less investor protection, less clarity, and more embarrassing defeats for the SEC. During that intervening time period, there was an opportunity for my Democratic friends across the aisle. In the absence of leadership from the SEC, they could have stepped up to the plate and offered their own solutions. They could have answered the call of some Biden-appointed officials like CFTC Chair Benham to provide greater authority to the CFTC to regulate this industry. They could have been part of the solution. They could have either done that in 21 or 22 when the Democrats controlled the House, the Senate, and the White House. They did nothing. Instead, we're here today listening to tired political rhetoric and not much substance. I understand that some of my colleagues don't like elements of this bill. That's okay. We're here to work out differences and move forward. My fundamental question is this: what is your proposal? If not this, then what? If someone wants to put out a proposal that protects investors while making a serious attempt to meaningfully regulate the industry, I'll take a look at it. I'm sure I wouldn't be the only one either. But if we've learned anything over the last 4 years, it's that the status quo is absolutely unacceptable. It doesn't work for investors. It doesn't work for the industry. No one is better off by keeping things as they are now. The reality is there's only one bill out there that provides the CFTC with the spot market authority over digital asset commodities. There's only one proposal out there that provides meaningful investor protections and works to apply the principles of security law to this novel asset class. And there's only one bill that would provide regulatory stability needed to secure America's place as a hub for blockchain innovation. Instead of politics, let's roll up our sleeves and do the hard work of legislating. If you don't like the bill as it is now, engage with the chairman. Engage with the subcommittee chairman style. Instead of a show hearing, let's engage in a dialogue that can get us closer to regulatory clarity. Thank you.
Will the gentleman yield?
Will the gentleman yield?
Yes.
You're concluded? I appreciate the time. I would note to my colleague, Mr. Sherman, on a sidebar here, the work we're doing in the investigation into Act Blue actually addresses the concern you raised, that an individual, just for awareness, an individual can make a donation in a credit card of someone else and load that information in, and there's no process that catches that. Maybe we have an opportunity to actually engage in some of the work we're doing on improving our campaign finance system. I'd note that. I'd also note to...
Will the gentleman yield?
we have 25 seconds, but I'll have a sidebar with you later because I actually think we could do some really good work in this space. And I would just build on a note that the ranking member said when she was speaking of her bill. She said, quote, "My bill is all about stopping Trump," end quote. I believe that speaks volumes about the other side's work in this space. Mr. Flood, I yield back to you.
That's what it is.
Gentleman yields back to Mr. Flood. Mr. Flood yields back. The gentleman from Connecticut, the ranking member of our Intelligence Committee, Mr. Himes, you're recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you to Ranking Member Water for holding this. Mr. Stein, I'm going to answer your prayers for a discussion on the substance of the bill. The context here, though, is, as I think you know, I've been a yes vote on both stablecoins bill and FIT 21. I'm struggling on this one for two big reasons. Number one, the innovation point. I've been a yes because of innovation, but 8 years ago I was promised flying cars, and instead I got FTX, and time has passed, and I just don't see the applications out there compelling enough to take a big risk on what is untrodden territory. I don't agree with the witnesses in some cases, by the way. Decentralization, it is very vaguely defined, but decentralization is a new thing. We learned this in Bitcoin. It is a thing, and I think it is an innovative thing. So then I'm left with the question of, Mr. Massett has called repeatedly for more jurisdiction and scope of action for the regulators. So then I ask myself the question, will the regulators get decentralization and maturity and all these new novel concepts right? And I look at those regulators and I say, do I trust these? And I look at my colleagues with whom I've worked with a long time. Have any single one of them, I'm not going to get into the Trump thing, but has any single one of them condemned the corruption that we're seeing in the White House? The Senate bill on stablecoins apparently carves out activities by the President and the Vice President. So I'm struggling on this one, and I want to ask two questions. Number one, I keep focusing on Section 202 because it is a clear exemption for the offering of what would otherwise be securities, including language, and let me read you the language. By the way, I know the majority understands that this is a sensitive issue because in a week we went from $150 million of offering to $75 million in offering. Thank you. But this all seems to rely on the issuer intends for the blockchain system to which the digital commodity relates to be mature. I'm thinking of those guys in tuxedos that went to the dinner. I'm thinking about the legal difficulty of establishing intention. So my question to the witnesses is there any compelling, I asked this question in the larger hearing, is there any compelling reason for the existence of the 4A8 carve-out Section 202? I got cut off by the chairman because my time was up in the last thing. I asked the witnesses in the other hearing, is there a reason to have that? And nobody jumped to the mic. So my question in my remaining 2.5 minutes is, what is and I'm happy to enter into a colloquy with anybody on the majority side, what is the reason for the exemption, and what are the risks associated beyond what I just outlined of trying to determine the intention of my tuxedo crowd?
I'll jump in, Congressman Himes. That's a great question. I would say that offering exemption is extremely permissive, and not just because of the vague intentionality, requiring a psychiatrist to determine the intent of the issuer, but the offering limitations are way broader than anything that exists in Reg A, A+, D, crowdfunding. So we are tipping the scales to push issues.
Interrupt you very quickly there, because attorneys that have been supportive of the other side on this have said that it actually mimics the liability standards and other characteristics associated with Reg A and Reg D, which, of course, as you know, allows for retail solicitation. So be specific with me on how this is different from traditional Reg A and Reg D.
You can offer larger offerings in terms of monetary value, no limits on accredited investor.
You know this is capped at $75 million in the draft, right?
Per year over 4 years,
okay,
which can be waived by the SEC to go further. You can sell to non-accredited investors. There's no limits on general solicitation. And FIT 21 had limits on per-person ownership that teed to income or wealth thresholds, and that gets rid of it. But I have an important point. I don't think any issuer will even use this new exemption because there are so many ways to issue tokens and claim that they are digital commodities at the outset, claim that they're collectibles, meme coins, whatever. So I don't.
How do you do that without violating the or crossing the Howey test?
Coinbase in court with the SEC said that all the tokens on their platform were collectibles akin to Beanie Babies. It's going to require robust enforcement by the SEC, just as in the last administration, how we went whack-a-mole to try to find the unregistered investment contracts. They will go whack-a-mole to try to find the unregistered investment contracts, because no one will avail themselves of the new exemption, because it's so easy to raise capital outside of it, and it's going to require the enforcement division marauding around for people that violated the exemption.
And if I can add a few things, Congressman, I think the argument as to why it's needed wasn't really answered. I've heard the following explanations. One is disclosure. And there are some thoughtful provisions in here as to what type of disclosure would be appropriate for this type of a
Gentleman's
sale.
time has expired.
I'll come back to you on it.
Gentleman yields back. I recognize myself for 5 minutes. And first, let me say to my friend from Connecticut, of course, we're very happy to engage in a constructive dialogue about the exemption and the structure of the exemption. Hope you'll work with us on that as we not only prepare to mark the bill up, but carry on the discussions even post-markup as we prepare for working with the Senate on a bicameral basis on this legislation. A couple of comments. You talked about, the gentleman from Connecticut talked about use cases, and I think that's been an interesting thing over the evolution of the digital asset space, something that the gentleman and I have certainly talked about before. Representative Torres has a study in the bill, I think, that talks about the value of what he's seen in our stablecoin bill and for stablecoins outside the U.S. on financial access, financial security, financial availability, and the power that he's seen outside the U.S. in lowering the cost. And that's one of the key things I think about writing applications on a blockchain, is lowering the cost. And my colleagues on both sides of the aisle, I think, acknowledge that blockchain operating systems and distributed ledgers definitely have value, and I've heard them all at one time or another acknowledge that as they've seen both corporate America and entrepreneurial America begin to experiment and write applications in this space. For example, you look at Filecoin, which is a distributed token on a decentralized ledger that's now it's been litigated in the past, that's true, but it's deemed decentralized. The benefits to public libraries and university libraries to be able to use their excess computing system and be paid for that excess computing system by the Filecoin system, for example. Consumers benefiting from one of the biggest companies in the world, Franklin Templeton, that's offered their money market fund on a blockchain that's resulted in lower expenses for consumers and their ability to offer a money market account down at a $500 level, offering more financial access to that savings vehicle at low cost with lower better fraud protections, better accuracy, lower bookkeeping costs, and Franklin Templeton has demonstrated in this one experiment of taking a money market fund and putting it on a blockchain of the benefits to consumers. And there are others, as we all know, the cross-border benefits of the dollar being used on a blockchain to lower agency costs for remittances or for business transactions. You know, in preparing for the hearing today, I went back and pulled the FSOC, the Financial Stability Oversight Council report on digital assets that was produced quite ably and under Secretary Yellen's leadership in the Biden administration. And it says the FSOC recommends the passage of legislation for providing rulemaking authority for federal financial regulators over the spot market for crypto assets that are not securities, steps to address the regulatory arbitrage, including coordination, legislation related to regulators' authorities to have visibility into and otherwise supervise the activities of all affiliates and subsidiaries of crypto asset entities, and appropriate service provider regulation. I turn to Ms. House, who is a distinguished service in the Biden administration. Do you agree with that statement, and is it important to fill the regulatory gap over the spot market for digital assets?
Yes, I support the FSOC report as well as that statement that we need to.
Thank you. And former Chairman Massa, do you agree with the report's assertion and the spot market regulation?
Yes, I do.
Thank you very much. Ms. House, you know, in your view, could the creation of a new digital asset registrants at the CFTC to oversee the trading of digital commodities also help fill this market gap?
I think it can, as long as it's matched with enforcement, which is a concern I have.
Yeah, couldn't agree more, and I don't know that there's any disagreement that we have strict enforcement, and that we also remind everyone that the base law in securities and commodities exists in addition to what we're adding through clarity, meaning all the anti-manipulation, anti-fraud provisions in both markets are federal law. They stand. Because I think that's good news in her point, because the Clarity Act addresses exactly those entities and the comments that were made in the FSOC report. Related, stepping down a little further, Ms. House, do you agree that the joint rulemakings that require the CFTC and the SEC to coordinate the oversight, supervision, and I'll add enforcement in the digital commodity marketplace is a step in the right direction?
Step in the right direction, accepting my concerns about a lot of gaps, but on the need for it to be joint, I think is exactly where we need to go.
Good, and we welcome, comments if you have on enforcement. And I yield back the balance of my time, and I thank the panel for being with us today. Turn to the gentleman from Illinois, Mr. Kasten, for 5 minutes.
Thank you. I am going to either embarrass myself or my family by telling you about what a dork I was in August of 1986. There was a comic book store down the road from my house called Fantasia. There was this guy, Danny, picture comic book guy from The Simpsons. He was kind of that guy. And he convinced me that Spider-Man issue 252, Google it, was going to be a collectible because Spider-Man, for the first time, was in a black costume, and that was going to be worth a lot of money. And he convinced me to give him $10 for a comic book that on the shelf was 60 cents. I do not know what it would be worth today, but I bought it, and I remember my mom screaming at me, going down, yelling at Danny, how dare you take advantage of a 14-year-old kid, convincing him to spend, a couple weeks' worth of allowance on this Spider-Man issue. The Clarity Act says that meme coins are collectibles. I don't know what that is. The SEC has taken the position that meme coins are collectibles and not considered securities. So I guess, Ms. Fisher, is that different from the Spider-Man comic that I have somewhere in my house? Like, if it's a collectible, I know what the Howey test is for securities. I know what a commodity is. What is a collectible, and where does that live jurisdictionally?
So I actually think it's easy, and I think you look at a facts and circumstances determination based on the offering. And if you look under Howey, it comes down to investment of money. Yeah, you're giving money for the comic book or the meme coin. With the expectation of profit, yeah, the guy told you the value of the comic book would go up based on the managerial efforts of others. There's where it comes in.
But I guess, I'm not arguing that Danny should be subject to an SEC. I don't even know if he's still with us.
I don't think he should.
What I'm asking is, if we have agreed that this is a collectible, it's by definition, it's now not a security, it's not a commodity. Does anybody have jurisdiction other than my mom?
I think that there's probably FTC jurisdiction over marketing and sales of collectibles, but when the proprietor of that collectible represents to you that they are going to create an ecosystem to make that collectible go up in worth, and that this can be a lucrative investment to you, and there's testimonials and LinkedIn profiles, then we start looking like a security.
Okay, so Mr. Mossad, if meme coins are carved out of the definition of digital commodities, doesn't that mean that Trump wouldn't have to disclose any information about his meme coins that he's issuing? And this ain't Trump derangement syndrome. This is because I give a rat's ass about the Emoluments Clause of the Constitution.
I think that's right. I mean, if the SEC is saying they're not securities and they're carved out of digital commodities, then there's still no regulation of them. Now, you could say these really shouldn't be treated like a commodity product that the CFTC regulates, but the fact is what's happened in this industry is because there's been no regulation, we have had so many things like meme coins where people are just pushing up the price and people are getting defrauded. And so we need to create a regulatory framework around that, even if you then say, okay, maybe we're going to treat these as gambling and we're going to have gambling regulation of them.
So let me just pick up this a little bit more. This dinner that Trump had at the White House, Lincoln bedroom on steroids, there was people there from Magic Eden who trade digital trading cards, which sounds like something I could have bought at Fantasia. Earlier this week, it was reported that Trump has partnered with Magic Eden to issue a digital wallet. Section 105 of the Clarity Act says that users' rights to self-custody engaged in peer-to-peer transactions don't have to comply with any anti-money laundering rules, which I think the issuance of this digital wallet would qualify. So, Ms. House, under this bill, would Trump's meme coin digital wallet be required to monitor or pay any attention to who its customers are? Just yes or no?
By my read, no.
Would they be required to keep any records of transactions?
But by my read, no.
Would they be required to report illicit activity to FinCEN?
By my read, no.
Okay, so question for all of you in the time we have left. Is there a better way for bad actors to launder money to the President of the United States than with the Trump meme coins stapled to the Clarity Act?
No. And can I just go to this bit about self-custody? It's very simple. If I put my money in a Swiss bank account, I'm entitled to do that, but I'm not entitled to not report the interest on it under our tax laws. If I put the money under my mattress, I'm entitled to do that, but that doesn't mean I can then take the money and do something illegal. So it's fine to say people should be entitled to self-custody. That doesn't mean that their transactions are then exempt from the laws.
Okay, well, I'm out of time, but if any Chinese foreign nationals want to buy Spider-Man 252, it's $300 million. Give me a call.
Mr. Chairman, point of information. Mr. Chairman, if the chairman knew that according to Go Collect, issue number 25 in 1961 is now worth $3,600, would he permit a second round of questioning?
While the chair wouldn't present a second round of question, I would say that I've gone long casting on this, and I wish him well in collecting that. I've already texted his mother, and we're in partnership to do that, so I want to thank the gentleman for yielding back. We'll now turn to the gentlewoman from Massachusetts, Ms. Presley, for 5 minutes.
Thank you to Ranking Member Waters for convening this Minority Day hearing. Thank you to our witnesses for joining us. Today I'd like to speak not about market structure, but actually about people, specifically women and survivors of intimate partner violence. Now, we already know financial abuse is a core component of intimate partner violence. Abusers frequently control bank accounts, restrict access to money, stalk survivors through financial transactions, or drain shared assets to leave their partner economically trapped. With traditional financial systems, there are red flags and mechanisms to detect this, such as bank alerts and flagged withdrawals. But in the crypto world, these protections vanish. Abusers can stash funds in anonymous wallets, bypass court-ordered freezes, or empty crypto accounts without a trace. We've seen reports where a husband hid $500,000 in Bitcoin during divorce proceedings, and abusers used blockchain tools to exert coercive control. Professor Allen, you've researched this issue. In your view, how does the decentralization of financial services, such as in blockchain-based wallets, make it harder to protect survivors of intimate partner violence from economic abuse, such as stalking?
Well, thank you very much for this important question. I think it helps us to talk about the things that are not in the bill that should be, right? And there's lots of them. This bill doesn't address conflicts of interest within exchanges, it doesn't address the operational risks associated with blockchain, and it doesn't address the privacy risks associated with using the blockchain. Public blockchains are public. Anyone can see them. So if someone knows your public identifier, they can see every transaction that you do. And that can give away information about your location. It can give away information about if you're trying to siphon off funds in order, well, not siphon, but put away funds in order to leave an abusive partner. All of that is going to be visible for all the world to see. So that's before we even get to the issue of the abusers themselves using crypto for criminal purposes or abusive purposes. This publicity of the blockchain is something that this law doesn't grapple with at all.
You know, and certainly intimate partner violence is one of the most underreported crimes, making it, you know, challenging to quantify how many specifically have been victims of economic abuse. But it's safe to say that without those elements being added, that many could be vulnerable.
Of course. Yeah, no, I mean, without addressing the privacy issue, it's not just an issue for women, it's also an issue for immigrants who don't want their locations necessarily revealed. It's an issue for people being profiled by law enforcement officers. You know, this kind of publicity about literally every transaction you do being visible to the whole world is something that just hasn't even been the surface scratched.
Thank you, Professor. Traditional banks are subject to know your customer rules and fraud monitoring, but crypto platforms, especially decentralized ones, currently operate outside that framework. Professor Allen, can you expand on this regulatory gap and how it allows abusers to hide and move money in ways that would be impossible in the traditional banking system?
Yeah, so the thing about crypto and the blockchain is that the technology is actually very inefficient. It's slower and clunkier than your average database. Where it gets its efficiencies from is skipping regulatory requirements that apply to others, including AML and KYC checks. So using this technology, the end goal is skipping that process. And so when you have fewer barriers along the way, then there are fewer intervention points where law enforcement officers and others can crack down on illicit activity, including using funds in ways that could be used to harm women.
Right, fewer barriers, fewer intervention points. I'm particularly concerned by reports where abusers access their partner's crypto wallet if they know the password and raid the account, preventing their partners from recovering lost funds since crypto transactions are irreversible. Let me just close here and say that the promise of decentralization may be empowering for some, but for survivors of intimate partner violence, there's often no recourse due to the regulatory gaps in our system. We cannot allow blockchain tools to become safe havens for abusers and predators. Congress in the whole needs to close these gaps. Protecting survivors of abuse should not be a partisan issue, and it certainly should not be an afterthought in our digital financial future.
The gentlewoman's time has expired. The gentleman from Illinois, Mr. Foster, the ranking member on the Subcommittee on Financial Institutions, is now recognized for 5 minutes.
Thank you. It is frequently struck me in these conversations that there's a relatively straightforward way of dealing with all the abusive things we've been talking about, which is simply to have mandatory KYC on wallets. This is not a big burden on someone using crypto assets. You simply, whether you spin it up on your hardware wallet or you go to some platform and get a new wallet, you just register it with FinCEN. I mean, this thing can take half a second. To say, okay, you present a secure digital ID that proves you are who you say you are, and this is your wallet. And at that point, anyone who deals with you in the future can have an assurance that the person on the other side of that transaction is, if necessary, if you prove a crime has been committed, that there's a legally traceable person at the other end of that. And Ms. Fisher, you had mentioned that there actually have been Republican proposals for mandatory KYC on wallets. Could you go through that for a moment?
That is true. When Secretary Mnuchin was at the Treasury Department, the department did, during a different political environment.
So this was back when President Trump thought crypto was a scam?
I believe that is true, and there was significant pushback from the industry, and that proposal was never finalized. But to give them credit, I thought it was a really robust, good effort, and I would have liked to have seen it continued.
Yeah, it seems like that would solve a bunch of problems. For example, if you could just have your software look on the blockchain, make sure that there was a continuous chain of transactions among KYC wallets, then you'd know in some sense that this was clean money, that it had not just been used for drug smuggling or human trafficking or all the other abuses you worry about.
I think that that's correct, but I want to have two provisos. One is we still have mixers that operate, and the government, under the Biden administration tried to track down on these services. They are open source code that literally lets people scramble wallet addresses so they can't be tracked, and it's how North Korea launders a lot of money. And two is...
But still, if there was mixers, if you had a requirement that all legitimate transactions had to have 100% KYC upstream of those, after some date of enactment of some legislation, then anything that went into a mixer that was un-KYC'd would just pollute the entire output of that mixer. as a matter of law, and would seem to solve that problem.
I think we need to think through the consequences of that, but I was going to mention one other point, which is the rules are only as good as enforcement of those rules. And the Trump administration, the Justice Department put out a memo in April saying that they were effectively ceasing enforcing the Bank Secrecy Act against a host of different crypto companies, including virtual currency exchanges. So when there is an explicit policy of non-enforcement articulated by the Department of Justice, it makes me a little bit nervous about the efficacy of the rules.
So that the idea of KYCing wallets solves a lot of the illicit finance problems. It doesn't necessarily solve market manipulation. If you're talking about an asset which has a fixed value, stable coins, for example, the main worries are whether the backing assets are safe and sound. And you don't worry about market manipulation. But if you're talking about the NFT market that collapsed just a shower of front running and wash trading and everything else, it seems like if you ever want a healthy market in that kind of asset, you need to have some regulator that sees the true identity behind people on both sides of every trade.
I think that that's extremely true. I would add that the SEC endeavored to do this with a consolidated audit trail in the equity space and made a bunch of progress, and now there's progress rolling back on that. So again, getting the rules in place is incredibly important, and then having the fortitude to enforce those rules and see them through is also important.
Yeah, Mr. Masson.
Yeah, I would agree with your comment, Congressman, and obviously one of the problems on the digital trading platforms has been things like wash trading that have been such a high amount of the total volume because that's a way for people to push up the price. So, the idea of regulating those platforms is good. The problem with the Clarity Act is it doesn't cover all of those tokens. Again, maybe some of them ultimately shouldn't be regulated as commodity products, but I think to start, you've got to impose a regulatory framework around them to prevent the kinds of market manipulation things you're talking about, and then decide, maybe we can regulate them in a different way as gambling or something like that.
Yeah, and so that would the United States equities and commodities markets have their dominant position if we allowed anonymous trading?
The gentleman's time has expired. You can provide additional comments for the record. The gentleman from California, Mr. Liccardo, is now recognized for 5 minutes.
Thank you, Mr. Chair. Ms. House, I'm very interested in what you said in your written testimony on page 7 about DeFi and the importance of taking steps to address this regulatory perimeter. It seems as though where we're seeing the industry going, maybe a couple years ago, perhaps 5% of transactions were DeFi. It's increasing rapidly, and I'm guessing it's going to be a majority of transactions very soon. And I'm concerned about this bill and essentially launching a global naval strategy and putting all your ships in Lake Superior when you know there's an ocean out there that you're not covering. And so with regard to DeFi, I understand we may not get to the place, as Mr. Foster suggested, where we have KYC for all users. But at the very least, we should probably want to create some kind of safe harbor or sandbox, as it's often called, for users. I imagine some users may want that because they don't want to be defrauded, and they want to know that if they are defrauded, they can litigate and get a subpoena and find out who just defrauded them, so there could be some action. How would you address in the DeFi context the need to create some sandbox?
Thank you so much for the question, and I appreciate the point, since sandboxes, of course, have boundaries and guardrails, right? Like when you think about most of them, like there's the little wood pillars, and then the area where kids are playing inside. So I think that it's thinking about what those guardrails and protections should be. When I think about it, FinCEN, the anti-money laundering regulator, our sandbox authority was called acceptive relief, and generally that could work in a timed delimited basis where we said, great, you can operate. Tell me what relief, what obligation you want relief from. And let's talk about how we can monitor whether or not this new approach, this innovative technology, is mitigating that risk. those kinds of sandboxes, I think, are the right ways to think about this, to put in place those guardrails. I appreciate Congressman Foster's point on digital identity and his great work on, I don't know that KYC for every unhosted wallet and the essential equivalent of having like, an identity tied to your peer-to-peer transfer everywhere, but also appreciate Congressman Himes' point that decentralization is unique and special. I think the work that the CFTC TAC did to outline that we need to assess the regulatory perimeter. I know we talk about that crypto is intermediary-less. That's not entirely true. It's not regulated intermediaries, but I'd say that I view that entities at the network layer, validators and miners, are intermediaries. The transactions cannot occur without their intervention. That does not mean that I think that they're MSBs or regulated in another way, but that kind of consideration of other areas in the tech stack and the ecosystem and moving the regulatory perimeter is what the CFTC Tech Advisory Committee suggested really deserves a strong assessment and evaluation of the ecosystem, where the points of visibility and control are, where burden would be highest or lowest. That kind of really concerted effort has not happened. It's absent from this legislation. I feel that kind of effort jointly between the CFTC and SEC and with the other regulators as well would be beneficial to mitigate the major risks that have been highlighted on the DeFi side.
And I recognize there's a difference of view on the committee about the extent of regulation. This is, I know, ideological and historic, goes back many decades. Is there room for there to be a mandate for an SRO here to accomplish some of these tasks? That is an industry-run mechanisms. I know that there are those who believe that NFA and FINRA are not adequate for crypto. Should there be a separate crypto SRO?
My general position is that I don't think that we need another one. I think that empowering the existing ones is best. But either way, I'll take it. If the industry would start regulating itself, that was something that we certainly, when we were at FinCEN, encouraged them to do in order to drive better, implementations of standards, development of RegTech solutions, cybersecurity standards and capabilities. That there has been some evolution in that space, but not enough, not nearly quickly enough to deal with the risk. So I think that there's room for it.
And then finally, just on this question of collectibles, if we assume for a moment collectibles aren't securities and they're not even commodities, how exactly do we regulate them? How should we? At this point, we think FTC may have some regulatory authority. What's the right approach?
This is tough. I think an economic function-based approach is the right one because those things can turn into, I think that something could be called a collectible by label, but may not function that way. And especially since a token can represent anything, whether a deed to a house or a piece of information, and blockchain is function neutral as a technology, we need to think about it based on that economic function, and that's the principle to use.
The gentleman's time has expired. The gentlewoman from Texas, Ms. Garcia, is now recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you to all our witnesses today. And Mr. Masada, I wanted to start with you. Does this act in any way, as currently drafted, support or hinder the goal of building a faster, cheaper, and more transparent remittance ecosystem, especially for immigrant and low-income families that are underserved? That is something that's been a selling point from day one that, frankly, I don't buy. But now that we have this Calamity Act, do you think that it gets us there?
Congresswoman, I don't think the Clarity Act goes to that. I do think stablecoin legislation can potentially help. State remittances are one of the potentially useful, use cases of stablecoins. Of course, we've got to make sure we have a proper regulatory framework, and there's a lot of issues about whether they would be as efficient if they complied with regulation. But I think more in terms of stablecoins dealing with the remittance case than this legislation.
Right. The professor, tell me what the profile is of the average investor.
Sure. So I'm glad you asked that question as a follow-up to your previous question, because what we're actually seeing is pretty low use of crypto for remittances. Right now, stablecoins make up less than 1% of people, according to the Federal Reserve.
That doesn't surprise me, but
yeah.
who is using it? Is it just the people who do want to cash in, perpetrate fraud, money laundering?
No, there's a lot of...
Because I keep hearing of, we really need this, we need, So we're not protecting the average American in this bill, are we?
Well, the average American doesn't use crypto, so let's be
Correct.
clear. But
Well, that's why it doesn't.
You know, but the small group of Americans that use it for legal purposes are primarily using it for speculation and gambling. And so the question you have to ask is, you know, as we're going into a place of increasing economic precarity, do you want to make people essentially do Hail Mary bets to try and keep their head above water, or do you want to actually take steps to make the financial system fairer for everyone? Because what I see here is not investor protection, it's encouraging people to gamble. And I don't think that's a viable way of dealing with financial and economic precarity.
So this is sort of like, let's build a bill that can make Trump richer again.
And the crypto industry too.
Well, the crypto industry too, but again, what is the profile of the average investor?
The average investor is, I think, typically a young man. You do see disproportionate, according to some surveys, disproportionate use by Black and Hispanic Americans, which to me I find concerning because I think that's predatory inclusion, much like subprime mortgages were. I think the most vulnerable people are being targeted, but also there are young men who are less vulnerable who enjoy the gambling aspect.
And what's the average investment that they make?
That I don't know. I'd have to get back to you on that. I'm happy.
Do any members of the panel, can they help me here? I'm just trying to, you know, it seems like we're spending so much time when we're getting this upper, you know, the other side seems to be ramming this bill to protect Donald Trump's investments. So that he could just get richer. I mean, is there anything in here for poor people, for people who,
No.
you know, is there anything here in this bill that's going to protect them if they do decide to gamble and take a risk?
No, and it's further to a point that I made earlier. The thing with this technology is you can't reverse transactions. So this is a place where fraudsters have really sort of congregated, because if they can induce you to send the crypto, it's gone forever. We're seeing stories of these Bitcoin ATM kiosks cropping up in places where you have check cashing and payday lending services, and they're not really ATMs because you can use cash to buy crypto, but you can't get cash back out again. And what we're seeing is stories of people walking into bodegas on a phone with a scammer, being told to put their money into the Bitcoin ATM, and then that's the end of the money. They never see it again.
No protections, nothing. So really, this should be called the Protect Corruption Act.
Will the gentlelady yield?
Yes, ma'am.
Thank you very much. Mr. Naylor, once more, can you describe quickly how many ways that Trump is stealing and promoting his crypto?
Well, I can't count that high. But the Trump meme is, by his own account, worthless, and yet he has made hundreds of millions of dollars simply in trading fees. Now, it's difficult to believe, but he has something that's even worth less, and that's the World Liberty coin, where if you buy it, that's it. You can't sell it. There's nothing.
Thank you very much.
The gentlelady's time has expired. I'd like to thank our witnesses for their testimony today. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses to the chair. The questions will be forwarded to the witnesses for their response. Witnesses will please respond no later than July 11th. This hearing is adjourned.
Thank you.